Shruti, you sit here. Any mention?
Please, Lordships.
Costless choice no.
Costless?
She is looking for a costless. Now my costless is missing.
Please, Lordship. I beg to mention item number 7. Lordship, I humbly pray that the matter.
This matter has been heard.
No, Your Lordship. After
Made by the appellant. This is matter after vacation.
Obliged, Lordship.
Yeah, please, Lordship, I beg to mention item number 11 and 12. On the joint request, Lordship, the matter may come up after vacation.
25.
11 and 12, Lordship.
Same order on private reading. Fine.
There is item number 6 also, Lordship. Item number 6.
Yes. But this matter has been heard.
Yes, Lordship, he has to.
So, Guru?
My lord, 5 years also there, and that is going to consume.
No, okay. You are prepared with 5, not with
5
6.
years also there, 6 years. I am prepared for both.
We will take.
We'll see how it goes.
Yes, Lordship.
Please, Your Lordships. Lordship, I beg to make a mention of item number 8.
After vacation.
Lordship, similar prayer for item number 13 and 14.
Item number?
13 and 14.
Same order.
After vacation.
Much obliged, Your Lordships.
May I please, Your Lordship? I beg to mention item number 9 and 10, my lord. Let the matter may come up after winter vacation.
After vacation.
Oblige, Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 15.
After vacation.
Highly obliged, my lord.
Yes. Anything else?
Lordship, I am looking for Mr. Yobin item number 14, Lordship.
14, it has been adjourned.
Release item number 1.
It pleases your lordship. Lordship, I have filed the citation, your lordship. The authorities which we rely on.
Have you filed?
Yes, your lordship.
You have given him copy?
Yes, I have.
Just now.
You are ready?
I'm ready, madam. But have you closed here?
No, lordship, I have to show you like which citation which we rely, which paragraph.
Okay. Yeah. You can go get those thing types. You can go and just type out those orders. Let Kraus it.
Lordship,
Yes, please.
in this Ram Narayan versus State of
What's the citation?
Punjab. Citation, it's AIR 1975
Where are those?
SC page number.
It's not with us. Have you supplied?
Yes, your lordship.
Or you've given the list of books?
Yes, I've given the list of book.
Okay. Pass over. We'll take up the next case. Let the books be key. Apne want ki cut sir. Next matter. Item 6. Item 6.
John sir.
Come on, Jad.
Item number 6.
Nếu pan adjournment hầm ai.
Take time.
Yes, what is the citation?
Lordship, AIR 1975, Supreme Court, page 1727.
Para?
Paragraph number 13 and 14, Your Lordship. It's at paragraph 13, Your Lordship, and 14.
Yes.
May I read, Your Lordship? The High Court appears, paragraph number 13, Your Lordship. The High Court appears to have overlooked most of the circumstances discussed by us which were extremely damaging to the prosecution case. The High Court has lightly brushes aside the inconsistency between the medical evidence and the prosecution version. The question of the time of occurrence having been shifted from 8 p.m. to 6:30 p.m. Have been blindly believed, as also the evidence regarding the prosecution of the weapons by the accused. In view of these striking circumstances, we should have expected the High Court to have approached this case with much more care and caution than it has, particularly when a death sentence was involved. Lordship, paragraph number 14. Where the evidence of the witnesses for the prosecution is totally inconsistent and with the medical evidence or the evidence of the ballistic expert, this is most fundamental defect in the prosecution case, and unless reasonable explained, it is sufficient to discredit the entire case. In Mohinder Singh versus the state, 1950 SCR 832, open bracket, AIR 1953 SC 415, 1953 criminal LJ 1761, this court observed in similar circumstances as follows. In a case where death is due to injuries or wounds caused by a lethal weapon, it has always been considered to be the duty of the prosecution to prove by expert evidence that it was likely or at least possible for the injuries to have been caused with a weapon with which and in the manner in which they are alleged to have been caused. It is elementary that where the prosecution has a definite or positive case, it is doubtful whether the injuries which are attributed to the appellant were caused by a gun or by a rifle. It is obvious that where the direct evidence is not supported by the expert evidence, then the evidence it's wanting in the most material parts of the prosecution case, and it will be difficult to convict the accused on the basis of such evidence. While appreciating the evidence of the witnesses, the High Court does not appear to have considered this important aspect, but readily accepted the prosecution case without noticing that the evidence of the eyewitnesses in the court was a belated attempt to improve their testimony and bring the same in line with the doctor's evidence with a view to support an incorrect case. Lordship, in our case, it's similar like in our case, Your Lordship, when the evidence of the PW1 and PW3, it's like belated attempts to improve their testimony. When they themselves, they are not the eyewitness of the case, but when they came to the court and deposed before the court, they themselves said that they are the eyewitness. Lordship, and then in our case, Your Lordship, there is no medical materials. What is the cause of the death? The cause of the death is written in the in PW's 4, but no material to show why the cause of the death, Your Lordship. And then it cannot be corroborated with the evidence of PW1, PW3 and 4, Your Lordship. Another citation, Your Lordship. Lordship, AIR 1976, Supreme Court 2423, Lordship.
Ara?
Lordship, paragraph number 5, Your Lordship. Paragraph 5 and paragraph number 7. Paragraph 8, Your Lordship.
Paragraph 7 or 8?
Paragraph 8, Your Lordship. 5 and 8, Your Lordship. Lordship, from the beginning of this, the first Lordship, in paragraph number 5, it was discussed about the delay in filing the FIR. Well, it's similar in our case, Your Lordship, where 2 days delay they file the FIR, Your Lordship. Lordship, may I read, Your Lordship?
You read only the relevant portion.
Yes, Your Lordship. Lordship, in paragraph number 8, Lordship, if we make a thought in the page 2423, the last part of Lordship, it is the duty of the Lordship,
Yes, please.
it is the duty of the prosecution and no less of the court to see that alleged weapons of the offence, if available, is shown to the medical witness, and his opinion invited as to whether all or any of the injuries on the victim could be caused with the weapon. Failure to do so may sometimes cause aberration in the course of justice. In this case, it is impossible to say with certainty whether the injury was caused by the balam or by the bahala that were seized, and therefore whether it was Ishwal Singh or Harpal who was responsible for it. Even if one believed that on the day of the occurrence the former carried a balam and the latter a bahala, Ishwal Singh, convicted under section 302 of the IPC, cannot be sustained in these circumstances. It's same only in our case, Your Lordship, there's no materials to show. Lordship, another citation, Your Lordship. And then, Your Lordship, in this matter, there's the opinion of the doctor also does not show the materials, which in our case that there is no material to show that the cause of the death, then that incise wound in this matter, Your Lordship, it should be there before the prosecution to prove that the death of the victim in our case, in this case, Your Lordship, it's caused by some materials, but there's no materials in our we don't know the cause of the death. It's after the my friends submit, I think, Lordship, you may be allow us to reply that. Lordship, another. Lordship, AIR 1976, Supreme Court 76.
Yes.
This matter in this case also, Your Lordship, we rely on the medical witnesses only, Your Lordship, where paragraph 25, Your Lordship.
25.
Lordship, may I read, Your Lordship?
Please.
We take this opportunity to emphasizing the importance of eliciting the opinion of the medical witness who had examined the injuries of the victim, where specifically on this point for the proper administrations of justice, particularly in a case where injuries found are forensically of the same species, example stab wounds, and the problems before the court, it's whether all or any of those injuries could be caused with one or more than one weapons. It is the duty of the prosecution and no less of the court to see that the alleged weapons of the offence, if available, is shown to the medical witness, and his opinion invited as to whether all or any of the injuries of the victim could be caused by the weapon. Failure to do so may sometimes cause aberrations in the course of justice. Fortunately, in the instant case, the number, nature, and dimensions of the injuries of the deceased, as deposed to by Dr. Sonso, afford a sure indication that they were caused with three different weapons. There were 16 stab wounds, which fall into three groups, the wounds in each group being of almost identical length and breadth. Thus, the length of each of the wounds 1, 3, 4, 5, and 15 was 3 centimeter. The breadth of each of this wound, excepting that the number 1 and 15, which was slightly less, was 1.5 centimeters. Wounds number 2 was 3.5 centimeters, multiplied by 1.5 centimeters. The length and the breadth of the wounds was 15 was 2.5 into 1 centimeter. The length of wounds 6, 8, 11, 12, 13, and 16 was 4 centimeters each. Giving allowance for slight variation, it can be said that the breadth of these 6 injuries was very nearly the same. Lordship, in our in this part, Your Lordship, this paragraph, it's helped in our case, Your Lordship. It tells us that when the medical witness, when the opinion of the medical witness does not show any materials due to the cause of the victim, Your Lordship. That's all, Your Lordship. Lordship, we may be allowed to file the written argument, Your Lordship.
Okay.
This matter.
My lord, in the present case, my lord, there were five accused, my lord. And out of the 5 accused, my lord, 2 of the accused died during the trial, my lord. And those were Sri Loit Muru, Sri Kamai Muru. Both of them had died during the trial. And trial proceeded on 3 of them, my lord. Tening Muru, She Muru, and The Muru. The prosecution examined, my lord, as many as 4 witnesses, my lord. 4 prosecution witnesses. If I may take, my lord, firstly the FIR. Why I take your lordships to FIR is that my friend had placed a judgment right now, that is number 2, AIR 1976.
Delay in FIR.
Delay. There is no delay, my lord. What my friend has interpreted is that, my lord, FIR was first lodged at the outpost and thereafter it was sent to the, my lord, police station. So that took 2 days. However, there was no delay. So my friend has misinterpreted that, my lord. Kindly see, my lord. Page 1, my lord. Page 1 is the I cannot take your lordship to the type copy because everything has not been reproduced there. The original is page number 1. Kindly see, my lord, the date of the FIR is 16 November 1991 at the bottom left, my lord.
Yes.
And my lord, kindly look at the forwarding, my lord. Forwarded to OC Joy, PS for favor of registering a case under section 302/34 IPC. I will take up the investigation of the case. So that was received on, my lord, 1811. So there is a misinterpretation, my lord. Because the date of occurrence is also 1611, my lord.
Yes.
And date of FIR is also 1611. However, this was filed at Umulong Police Beat House.
Yes.
So there is no delay, my lord, in filing of FIR.
Yes.
My lord,
See, Mr. Guru,
my lord,
you go again to that page 1.
my lord,
You find here on the left side
my lord,
some signatures there.
my lord.
1811-91. Headman.
Yes. But the fact remains, my lord, the FIR is dated 16 November. That cannot be denied, my lord. So, my lord, this signature bearing the date 18/11/1991, my lord, that is not clear.
Who is the author of the FIR? Who filed the FIR?
FIR is the PW3, my lord. This the brother of the.
Then why there are 2 signatures? The FIR.
Yes.
Has he explained in his evidence?
I'm going through that, my lord. There is no explanation as to the signature of the headman, my lord.
See, this informant or complainant, he has also not, he has signed, but he has not, noted the date. We don't know whether he signed it on 16 or 18.
But my lord, the evidence of PW3 and the evidence of PW3, my lord.
When was the inquest conducted?
Inquest, my lord.
18.
18th, I think. I remember it's 18th. Page 87, my lord. 88 is the type copy. 18th, it was conducted on 18th.
So from 16 to 18, the body was lying in the paddy field
Yes, sir. They have explained, my lord, because as per the
because they could not take a body.
Yes.
Isn't it?
However, in this case, my lord, inquest report was not exhibited.
Oh, not exhibited.
Yes, that was the query of my lords. And my lord, I'm ready to, my lord, I'm ready with that, my lord. I have done some research on that, my lord. Whether in the circumstances inquest report is not exhibited, whether it will go to the root of the, that I have, my lord.
Please continue.
If I may take my lord to the evidence of PW1, which is at page 33. If I may read, my lord.
Yes.
PW1, Srimati Manda Muru. I know all the accused persons who are present in the court today. So, my lord, I'll take a pause here, my lord. What she says is that I know all the accused persons who are present in the court today. So, this is a doc identification, my lord. So, when an identification takes place in the courtroom, my lord, the witness is under oath and becomes a evidence, my lord. I know all the accused persons who are present in the court today. One Sada Muru, who is now dead, was my younger brother who died on 16/11/1991. He was murdered by all the above accused persons. I saw the occurrence myself, so she is an eyewitness, my lord. The occurrence took place around 6:30 p.m. to 7 p.m. on the said date at the paddy field belonging to my mother, Ka Kyumuru at Lumkudung. Immediately after the incident, I asked them as to why they killed my younger brother, who was not mentally sound. I further asked them why they did not inform me and my family before killing him, and to which they replied that they had already informed my family members, which in fact was not true. I do not know the reason why they killed my younger brother. In the cross-examination, my lord, I was at my place of work from 13/11/1991 to 16/11/1991 at Sung Valley, where I make harvest of my paddy. I reached home on 16/11/1991 at about 6 p.m. The paddy of my mother is at Lumkudung village and met at Sung Valley. From Sung Valley, I reached my house first, then the paddy field of my mother. On reaching home, I took my meal and get ready for bed. Then at that point of time, the accused came and dragged my younger brother to the paddy field of my mother. At that time, my brother U Sudamuru, U Kiamuru, Ka Queenmuru, U Nihon shooting were all present at home. Then we did nothing to follow the accused along with our brother U Sudamuru and asked them not to beat him. The distance of the paddy field from our home was about 100 meters. The time when they dragged him from our house is just before 7 p.m. During the dragging process, the accused person also manhandled my aunt, brother U Piamuru, my father also.
Should be my other brother.
My lord?
Should be my other brother.
Yes. Also manhandled my,
Should be other.
in my copy is aunt brother. Huh?
It should be other.
Other brother.
How can it be aunt brother?
My father also, who Nihun shooting, was assaulted by the accused. We did not inform the headman about the incident on the said date and time, but have, however, made hue and cry, to which no one came to the rescue. It is a fact that my brother Usudamuru was left in the paddy field on 16/11/1991 till 18/11/1991. On being inquired as to why she did not take her brother Usudamuru to her home, immediately she replied that her religious practice in a name tray, it is not permissible to carry home. Something is missing, my lord. In case of a person who met with an unnatural death. It is a fact that my brother Ukiamuru reported the matter to the headman of Lumkudung on 18/11/1991, and thereafter a complaint was lodged with the police.
So here, see,
My lord.
here admitted that FIR was filed on 18.
My lord. It appears so, my lord. It appears. I stated that the FIR lodged by my brother is wrong to the extent that I am an eyewitness. I do not know who attacked first, the deceased. I was at a distance of about 3-4 meters from the place of occurrence. During this winter season on that particular night, it was still visible to the naked eye, though the time was 6:30 to 7 p.m. at night. I was not at all examined by the police. The police examined only my mother, Ka Kemen Muru, and my sister, Ka Soli Muru, on the 18/11/1991. Subsequently, I was examined by the police, and I have told them that the incident took place at 4 p.m. My statement before the police about the time is uneven, and my time before the court about the timing of the occurrence is correct. It is a fact that I never stated before the police that the accused person dragged my brother Usodamuru from our residence on the alleged date of occurrence. It is a fact also that I never stated before the police that my brother Ukiamuru and my father was assaulted and manhandled by the accused person. It is a fact that my deceased brother was a lunatic. It is a fact that my brother is hospitalized and is in mental jail, Shillong. It is a fact that my deceased brother was a criminal lunatic. It is a fact that only when he was provoked that he became violent. I do not know if my deceased brother destroyed the ripe paddy of the accused person. So, my lord, the question was posed during the cross, to which she has stated, I do not know if my deceased brother destroyed the ripe paddy of the accused. And this gives a glimpse of the motive, my lord. It is a fact, it is not a fact that my brother was not dragged from home on this date and time of occurrence. It is not a fact that my brother and the accused were already in the paddy field prior to the time of occurrence as stated by me. It is a fact that my deceased brother created trouble on time and occasion. Darwa Shillong directed us to hand over to the police and thereafter they sent him to mental jail Shillong. I was not present on 18/11/1991 when the police came to inquire into the death of my brother. I do not remember at what time the police arrived at the paddy of my mother on 18/11/1991. I arrived at the paddy field of my mother at about 8 p.m. on 18/11/1991. I was at home on 16/11/1991 at 6:30 p.m. I went to report the matter to the police on 17/11/1991. My brother was not taken to hospital for postmortem. Now, my lord, from the evidence, what has come out during the examination in chief and the cross-examination is that it is not disputed that PW1 on that particular day of the occurrence and the date of the occurrence and the time of occurrence, it has been established that she was very much present in the house of her mother. Secondly, it is also established that she is an ocular eyewitness to the occurrence, my lord. And she also established that that PW3 was also present in the house at the time of occurrence, my lord. So three things are very clear. And secondly, my lord, fourthly, that she has clearly stated that her brother was killed by the accused person. Fifthly, she says that the distance of the paddy field of her mother and the house where the PW1 along with other witnesses were present, that her brother was being dragged out from the home till the paddy field and the distance is about 100 meters, my lord. Now, my lord, this is a village scenario, my lord. The place of occurrence is a village where village houses are there and paddy field at a distance of 100 meters, lordship. What I am trying to say here, my lord, later on, my lord, as I argue the matter, my lord, I'll place some judgments, you know. Right here, just to, my lord, here the distance is the distance dragged. The victim was dragged 100 meters, my lord, from the house, village house, till the paddy field, my lord. A village place, my lord, house to paddy field can never be presumed to be as smooth as like our High Court compound, my lord. It has to be up and down with the stairs and no planned construction, rather muddy and stones, rocks. So, meaning thereby, what I am trying to, my lord, point out is that, as my learned friend has just pointed out, that the incise wound, the allegation here is that not a single witness has whispered about any weapon being used. It was by fist. So, my lord, with fist, whether incise wound can be, my lord, inflicted, that was one of the query of my lord. So, my lord, what I am trying to, my lord, explain is that this is a village place of occurrence, my lord, and being dragged for 100 meters, it cannot be assumed by no stretch of imagination that during the dragging for 100 meters in a village locality, that the victim won't, my lord, get injuries similar to, my lord, like banging of head on the stones on the road. So, my lord, so this non-explanation of, my lord, the incise wound that cannot be, my lord, inflicted by bare hand can be explained by this scenario, my lord. That is what I am trying
Is
to
there
say.
is it in evidence? Any of the witnesses have said what is the terrain? What was the
Exactly. That
what
is
was the condition of that?
that is missing, my lord. That is missing.
Whether it was full of stones or whether it was mud
That is
or
missing. But I have a
grass.
judgment which says that, my lord, that can be presumed, particularly when, my lord, the occurrence takes place in a village, particularly state of Meghalaya, like it's a hilly area, my lord. It is a hilly state. So, my lord, I have got a judgment to that. I'll come to that in the end, my lord. So, my lord, here the PW1 has established clinchingly, my lord, without any contradiction in the cross-examination, that she was an eyewitness and that she saw the occurrence and that she has named the accused people, that I know them personally. Not only that, my lord, she has identified them in the courtroom, my lord. Now, my lord, I have to read PW1 with PW3 conjointly, my lord, because just to prove that they corroborate each other, my lord. PW3 is at page 38, my lord. My lord, in the cross-examination of PW1, she has stated that PW3 was present at that point of time at home. Cross-examination at page 33, my lord, bottom portion. PW3, my lord. Kiamuru. I received summon to appear and depose before the court today. I know the instant case as the deceased victim Sri Sadamuru was my brother. I cannot remember the date, month and year of the incident. My lord, the occurrence was in the year 2019 and his statement was taken in the year 2022, my lord. So therefore, being a rustic village person, my lord, there is every possibility to, my lord, forget the, my lord, the precise date of occurrence, my lord. I cannot remember the date, month and year of the incident. On the day of the incident, I was at home along with my parents and my deceased brother at around 6 p.m. Once Sri Dal Rinklem came to our house and after some time he left our house. Thereafter my victim brother went out of the house and I saw 5 persons chasing my brother and caught him at the paddy field and started assaulting him. On seeing my brother being assaulted, I along with my parents rushed to the paddy field to stop those 5 people, but they still continue assaulting till he died on the spot. I know the 5 persons who have assaulted my brother and their names are Teningmuru, so they named everyone, my lord. All belong to Lungkudung village. Today only accused Shemuru, Teningmuru and Themuru and Teningmuru are present in the court today. All the accused persons are my cousin brothers. After assaulting my brother, all the accused persons fled away from the place of occurrence. I, along with my elder sister, Longmuru, went to Ummolong Bit House to report the matter to the police, and the FIR was typed by someone whose name I cannot remember. And now I have signed, and I have signed in the FIR. Exhibit 1 is the FIR, and Exhibit 1 by 1 is my signature. The dead body was guarded till the arrival of the police after 2 days of the incident. The police did some inquiry at the place of occurrence. I do not remember now if the doctor also came to the place of occurrence. Later the dead body was handed over to us for conducting the last rites. Later, all the 5 accused persons were arrested by the police. Cross-examination. It is a fact that I have informed the police about the incident at about 8 p.m. It is a fact that whatever I have deposed before the court today is true and correct, and the statement before the police that I was informed by somebody about the incident is not correct. It is a fact that me and my other 4 family members just stood at the place of occurrence requesting the accused not to assault the victim. But we did not do anything as we are all scared. It is a fact that only we, the family members, witnessed the incident at the place of occurrence and none of the villagers saw it. At the place of occurrence, it was me, my father, mother, and two sisters, namely Longmuru and Dinamuru, were present. The dead body of the deceased victim was lying at the place of occurrence for 2 days from the date of the incident. I saw that all the 5 accused persons together assaulted my victim brother. I had informed the police about the incident at Umrong Beat House. So, my lord, reading PW1 and PW3, my lord, one thing is established, my lords, that both PW1 and PW2 were eyewitnesses. They also identified the accused person, and their statement, my lord, corroborates one another, my lord, to the extent that how they were present in the house
Yes.
and how he was dragged, and the other one says saw him chased, and my lord, that they attacked him till the point of death. And it is further not disputed that this occurred at the paddy field of their mother, my lord.
So this father, mothers, and these two sisters, they were not examined. They were not brought as
No, my lord,
witnesses.
they here, my lord, it is at they died, my lord.
Okay.
The father also expired, my lord.
Yes.
So, my lord, I respectfully submit by reading PW1 and PW3 that they have established that on 16/11/1991 they were very much present in their house at Lungkudung village between 6 to 7 p.m. Evidence of PW1 and PW3 was not shaken during the, my lord, cross-examination. Rather, on the contrary, my lord, it has been confirmed in the cross-examination that they were present in the house at that point of time. PW1 and PW3, my lord, through their direct oral evidence, my lord, has established that they saw the occurrence, my lord, and they saw the 5 accused person, and they know them by name because they were cousin brothers, my lord, from the same locality. So this has been established, my lord. Now, my lord, the second point, my lord, I would like to take your lordships, my lord, whether the PW1 and PW3, being ocular witnesses, my lord, has stated that their brother died due to the assault by the 5 person. So whether the victim had died because of such injury, my lord, for that I'll take your lordships to the evidence of, my lord, PW5, the doctor who conducted the, my lord, postmortem. PW4, my lord. PW4. Page 40, my lord. I'll read directly from the second paragraph, my lord. In the year 1991, I was posted at Joy Civil Hospital. I received a requisition from the police to conduct the postmortem on the dead body of Sri Sadamuru, male, aged 23 years, at the spot place of occurrence. So postmortem was conducted at the place of occurrence, which is the paddy field. Here also, my lord, the place of occurrence is, my lord, established. It further corroborates the statements of PW1 and PW3 as to the place of occurrence, my lord. of the deceased mother, Queen Muru. The examination was conducted on 18/11/1991 at 2 p.m. So PW3 also stated that police had come on 18/11/1991. Thorax, walls, ribs, cartilages healthy. My lord, the relevant portion will be, my lord, page 41. After examination of the dead body, I found, page 41.
Yes.
After examination of the dead body, I found the head is broken, the membrane ruptured, lacerated injury on the chin, and the chin is broken, lower lips disfigured, incised wound on the left supratemporal region measuring 3 into 2 centimeter, upper jaw and 6 teeth broken, my lord. In my opinion, the cause of death was due to hemorrhage resulting from the above injuries. Now here, my lord, firstly, all the injuries, my lord, except number 4. Rest of the injuries 1, 2, 3 and 5, my lord. What PW1 and PW3 had witnessed that their brother was being mercilessly beaten and dragged and chased in the paddy field and killed him and attacked him. So, my lord, all these 1, 2, 3 and 5 nature of wound, my lord, is possible, my lord, with bare hand, and that too, it is during, my lord, winter season this occurrence had taken place. In winter season, my lord, that is not the harvesting period, my lord. During the harvesting period, my lord, the soil are, my lord, loose and wet, my lord. But during winter, at that point of time, the nature of the soil in the village where paddies are being grown, harvested, my lord, it becomes as hard as rocks, my lord, and it is not even also. Now the incised wound at 4. So incised wound, my lord, is something that can be caused by sharp object, my lord, which on the last occasion there was a query, my lord, whether in view of the fact that the witness they did not speak about use of any weapon, my lord, or nor anything was seized, in that scenario, whether incised wound can be attributed to, my lord, the attack by fist, my lord. Now, the final opinion is that, my lord, in my opinion, the cause of death was due to hemorrhage resulting from the above injuries. Meaning thereby, my lord, that the injuries which the PW1 and PW saw being inflicted on the victim, my lord, resulted into hemorrhage, and this hemorrhage resulted into death, my lord.
Yes.
Now the third point, my lord, I would like to point out is that whether the accused person had committed culpable homicide amounting to murder, my lord. My lord, culpable homicide coupled with intention and knowledge that the injury is sufficient to cause death, my lord,
Yes.
amounts to murder and punishable under section 302 of the IPC. From the evidence of PW1 and PW3, my lord, it emerges that 5 accused persons caught hold of the deceased. The deceased was dragged to the paddy field, and PW1, PW3 saw the assault, my lord. Not only that, my lord, they had requested the accused person not to stop and not to kill him, not to beat him, my lord. But they went on, my lord. So this clearly shows, my lord, that they were motivated. They had decided to do away with the life of the victim here, the deceased, my lord, which is why they assaulted him till the point of death, which has come out in the evidence of PW1 and PW3, and which is not at all, my lord, shaken during the cross-examination, my lord.
Where is their medical examination report?
It did not enclose. I think it is not enclosed, my lord, but it is not enclosed. It doesn't. Is there? No, in the charge sheet it's not there. My friend has not incorporated the.
Postmortem report is there on page 84, 85, 86 of the FR book.
The postmortem report, my lord. Page 82.
That is why we have to look at. Is there?
Yes, ma'am.
Which?
It starts from 82, and the relevant portion will be at page 84. The same has been, my lord, stated in the evidence, my lord. The head is broken.
No, this is postmortem of whom?
Postmortem, my lord.
This is postmortem report.
Yes, my lord.
No, I'm talking about the medical report of the accused. You see, when they were arrested, medical examination would have been conducted.
My lord.
If your theory that the deceased was killed by, or rather,
Fished.
by fist or without weapons, put it that way, then it would have been evident.
My lord.
There would have been some marks in their
My lord.
hands or
Definitely.
cut.
Absolutely.
That should be reflected in the
Exactly,
medical.
my lord.
Is it there?
My lord. It is not there, but however, my lord, even if the accused persons after their arrest were not medically examined, to that would have, my lord, as my lord has rightly pointed out, would have fortified my case as to the by my lord,
In what
if
manner
there was any injuries.
In what
on
manner the injuries was inflicted?
Exactly. So, my lord, the law, my lord, according to me, my lord, I have done some research on that. That when there is a ocular evidence, ocular witnesses, and there is a direct evidence, my lord, where witnessed the crime, even if
That is another aspect.
yes,
We are aware of that.
yeah,
If there is ocular evidence, Even though there is no
Yes, sir.
production of a murder weapon, the court will accept that.
Exactly, my lord.
But for our satisfaction, because
Exactly. That was not done.
that was the case that you have presented.
Exactly, my lord. From the, my lord, paper book, I am making my submission that there is no medical examination of the witnesses. But if it is in the LC record, that I do
Check
not.
the court. Open you. This. This one. This one.
Hmm? No, no.
This here. Please, sir, come earlier.
Mr. Gurung, what is the timing of death of the victim as per the post-mortem report?
Timing is not reflected, I think.
Timing is not reflected. There is a mystery then. The time of death is mystery then.
My lord, after all, my lord, even the post-mortem report, my lord, it is just an opinion of the, my lord.
We understand.
But,
If
my
it
lord,
is
in presence of, my lord,
then in such a case, there must be something in the evidence to show the time.
exactly, my lord. That has been brought out, my lord, in the evidence of
Timing of
PW1 and PW3, yes.
No, they say, see, they said that he was beaten till he died.
Yeah.
Yes.
And the time,
But then where is the mention of timing and all?
yes, it has been stated, my lord. I have read out. Between so and so to time, my lord, we were at home.
So according to you, that will fulfill the requirement.
It is coming from the, my lord, eyewitness, my lord. Even if post-mortem report, my lord, I respectfully submit, my lord, that is the expert opinion, my
See,
lord.
how when layman will know whether a person is lying unconscious or is dead?
Sorry, my lord.
Can a person
My
like say a person like me
My
who doesn't have any medical expertise?
My
Can I say that can I by looking at a person that he's dead or he's lying unconscious?
My lord, it's a.
Is
I'll
it not
say
that this is the job of an expert?
that is
to
there,
say?
my lord. But it is also admitted fact that, my lord, the dead body was kept at the place of occurrence for 2 days, my lord.
Exactly.
It is a, my lord.
That is why the timing becomes important. The court is asking you about the timing because of that.
My lord, yes, as rightly pointed out, my lord, but
So far as the medical evidence is concerned, it is not mentioned anywhere.
not mentioned.
That is all.
That is what. So therefore, my lord, when my lord, the medical, even if the medical, I have got a judgment to that effect, my lord. Even during the post-mortem, if the timing is not mentioned, my lord, but in view of the fact that eyewitness is stated about the timing, my lord, then in that view of the matter, my lord, the
Timing of the assault or timing of the death?
assault and timing, even the death also has been stated. My lord. He was beaten till death. Now, my lord, in any scenario, particularly what my lords has projected, my lord, that it is the duty of a medical
See,
expert
normally
to.
it is normal assumption that for
Yes,
a
yes.
layman,
It is the doctor who has to, my lord, find out whether he is dead or alive, my lord. But however, my lord, the place of occurrence is remote village, my lord. In the night
why
time,
you
my
going
lord.
to all those things? See, these are coming as your explanation. We are not
Exactly.
not on that thing.
Exactly, my lord.
We are not on that thing. What
Exactly.
we wanted to know is
So,
what
my
is
lord,
the,
5%,
what is the timing of death.
my lord,
So,
5%,
according to you,
my lord,
the timing of death
my lord.
basically has to be ascertained from the evidence of the PW1 and 3.
Exactly, my lord. Exactly. And my lord, PW1 and PW corroborates each other about the timing, about the nature of assault, and also the place of assault, and till death. They have stated, and nothing could be taken out during the, my lord, cross-examination. So that it stands proved, my lord, it becomes evidence based on which conviction can be passed.
Mr. Wong, what my brother has pointed out,
My lord.
from the evidence, we see that the incident occurred between 6 and 7.
My lord.
7 is dark,
Correct, my lord.
so you can see, how can you assume that the person who's, when it is dark, will know for sure that the victim is dead or not?
True, my
As my
lord.
brother said, he could have been unconscious for all we know.
True, my lord. True, my
And
lord.
during that intervening period of 16 to 18,
True, my lord.
2 days,
My lord.
somebody may have come and killed him, some animal or somebody else except the accused.
True.
Those are queries which those are questions which you have to answer.
My lord. Absolutely correct, my lord.
You have to understand this is a murder case.
Absolutely correct. But
And
how?
it has to be, you see, the evidence has to be, without a shadow of doubt
My lord.
that they are the person responsible.
Exactly.
If these, what should I say, loopholes are there,
Exactly.
then you have to explain that.
PW3 in his chief has stated that it was winter night between so time, though it was late, but it was visible. He has stated that it was visible.
You said that you have a decision which says that even the timing of death can be established by eyewitness.
Yes, my lord.
You have that.
I have, my lord.
Or you can refer it after finishing your oral address.
My lord. In fact, I have also, my lord, taken out my lord, the relevant paragraph of the decision also, and I prepared my written synopsis also, my lord. It is all there.
Okay, chalo. It's okay. You can.
So, my lord, I have led my lords to the evidence of PW1, PW4, and PW3, my lord. So, those are the relevant, my lord, witnesses. Total number of 4 were examined, my lord. So, from the evidence of PW1 and PW3, the time of occurrence, the date of occurrence, the place of occurrence, my lord, has been established, and their presence, my lord, PW1 also stated in the chief that PW3 was present at that point of time in the house, and vice versa. PW3 also corroborates the same thing, my lord. That apart, my lord, about the conviction under 302, my lord, that they had the knowledge because they had requested them not to kill him, not to beat him, but they did not stop. So, from there, my lord, it is clearly established that, and that apart, my lord, they were named as accused. All of them, they knew it because they were from the same locality, village, and also they were the cousin brothers, my lord, of the witnesses and the deceased, my lord. And they were also identified in the dock, my lord. In view thereof, my lord, the conviction and the sentence passed by the learned trial court below, my lord, suffers from no illegality, my lord. and requires no interference, my lord. That is my submission. And whatever my learned friend has relied on those 3 judgments, my lord. So in that scenario, because they are going to they are filing their written argument, so I'll just brush up my furthermore in my this thing, because there were some few queries also, my lord, falling from my lords. So I'll be filing my written argument covering those aspects, my lord.
Yes.
Lordship will reply it on the next date, Your Lordship, along with our written argument, Your Lordship.
Next there will be an application.
Yes.
By the time we come back, we'll forget about everything.
Yes.
But Mr. Letter Counsel for the appellant, who has concluded the argument on behalf of the appellant. Also heard Mr. R. Groom, Leonard G.A. for the state respondent, who has also concluded his argument. Next, the parties have prayed for written argument to be filed along with relevant authorities. Let the written argument be exchanged with the parties and to be filed in court before the within the next date fix. As prayed for, this is matter of vacation.
Deeply obliged.
Highly obliged, Your Lordship.
Any mention?
May it please your lordship. Your lordship, I beg to mention item number 4 from the main list. I'm appearing on behalf of Mr. J. Shilla, your lordship. Lordship, praying for some time as he's in bereavement. One of his family members expired today.
Premier by the petitioner. This is matter of vacation.
Much obliged.
Much obliged, Lordship.
From supplementary list, item number 1.
May it please, Your Lordship.
Yes, who's there?
Mr. Abraham is supposed to. Lordship, I'm praying if this matter can be taken at the end of the board. Learned senior is on his legs before the court number 1. Lordship, this
What is the matter about?
Lordship, this is a bail application, Lordship.
So,
No, Lordship. 105, Lordship, BNS, culpable homicide not amounting to murder.
yes, Mr. Chanda, you guys tell us.
In this case,
Tell us what is the facts of the case.
Lordship, here, Lordship,
here, Your Lordship, I bet about mental. Here, the petitioner is not the accused. The petitioner himself, the accused is not the petitioner in the instant
Lordship,
case.
she's
That's matter.
sister, Lordship, blood related, Lordship.
That has been decided by this court.
Lordship, time and again, Lordship. There's no bar in that, Lordship. Now, here, Lordship, what has happened is there was an FIR, Lordship, filed on 6/11/2025 by the in charge of the Nomansang Beat House, Lordship. That a body was found near Damsnyang, Lordship. Thereafter, Lordship, an inquest was done, and he was found that the person was dead and there was injury marks on his body, Lordship. And in the FIR, if I may draw your Lordships to the FIR, Lordship, that is of 26/10/25, Lordship. It's at page 9, Annexure 1. If Lordship permits me to read the FIR, Lordship. With reference to the subject mentioned above, I would like to inform that today, the 26/10/2025 at 8 am, information was received at the OP to the effect that there was an unknown male dead body which was found lying at Damsnyang near Mauswa, Shillong. Accordingly, staffs were sent for inquiry, where it is ascertained that the unknown male body, who was later identified as late Charlie Pingroup, was lying by the side of the Kacha road with injury marks on his person. On the arrival of the forensic teams along with the presence of the police officers, an inquest was conducted over the dead body and other legal formalities were observed at the place of occurrence, where it is ascertained that the cavity bears injury marks which was suspected to have caused due to an assault by one person, Sri Ankush Marbinyang. Lordship, I want to stress on this point that has been caused assault by one Sri Ankush Marbinyang and others. Subsequently, the cavity was sent to Nigrims, Shillong for holding a post-mortem examination and other legal formalities. In connection with the incident, it is strongly suspected that the above named person is suspected to have died because of an assault in his person. Therefore, I would like to request you to kindly register a case against the culprit involved so that necessary action may be taken from this end. Now, Lordship, what has happened after the filing of the FIR, Lordship? The police officers, Lordship, has started the investigation, and Lordship, on 6th, I was called, Lordship. Though there's no mention of my name in the FIR, Lordship. I, being the manager of Mr. Ankush, Lordship, I was called there and I was questioned, and thereafter, from the outpost itself, Lordship, I was taken to the police custody, Lordship. And 2 days police remand was requested, which was granted, Lordship. Thereafter, I was sent to judicial custody. There was no further prolongation of the police custody, Lordship. Only 2 days police custody were sought by the investigation agencies. Now, Lordship, here what has happened is, Lordship, if Lordship comes to page number 15 of the application, Lordship, these are the, Lordship, orders passed by the trial court, Lordship, whereby the main accused, Lordship, has already been granted anticipatory bail, Lordship.
Yes,
Lordship, that is order dated 4/11/2025, Lordship. If Lordship allows me to read, Lordship. See, I put up before me the bail application filed by Sri Ankush T. Marbinyang under section 482 BNSS for grant of anticipatory bail to him in connection with Rinja PS case number 31110/2025. Sri S. Thapa advocate and S. Chanda advocate appears for the petitioner. The petitioner was granted interim pre-arrest bail in connection with Rinja PS case number 31110/25 under section 105 BNSS wide order dated 29/10/25. This court has called for the case diary and the IO report in connection with the case. Learned additional PP Srimati J.K. Malak submits that she has no objection if the pre-arrest bail is granted to the petitioner is made absolute in view of the IO report. Seen and perused the IO report, who has stated in his report that the petitioner is cooperating with the investigation and leaves it to the discretion of this court to consider the bail application. Perused the case diary. There appears to be not much progress in the investigation. The involvement of the petitioner is also still not clear. Considering the materials on record, having heard the learned counsel for both sides, this court is of the constituted view that the interim pre-arrest bail granted to the petitioner be made absolute. The interim pre-arrest bail granted to the petitioner Sri Ankush T. Marbanyang is hereby made absolute on the same terms and conditions as in order dated 29/10/25. The petitioner shall execute a fresh bail bonds for a sum of rupees 20,000 only, with 2 sureties of like amount to the satisfaction of the court of learned JMFC, endorsed with police papers within 2 weeks. With the above directions, the application is allowed and disposed of. Case diary be returned to the IO. Thereafter, Lordship, what has happened after disposal of this, 2 other persons were called. They also have been given anticipatory bail, has been made absolute. Lordship, now all of a sudden, Lordship, without anything, there is no connection as far as with regard to this case, Lordship. But I am concerned. Lordship, what has happened is, on the day of the incident, there was a call received by Sri Ankush T. Marbanyang that there has been theft. The property belongs to Ankush T. Marbanyang. So there was a theft, Lordship, in the morning, wee hours of the morning, and there was a mob attack on this person. When we reached the place, Lordship, everything was done, and we reached the point when he was already, then he was chased from the property, Lordship, and he was outside. Thereafter, suddenly, Lordship, he fell on the road and died due to maybe injury, which I am not aware, Lordship. But there was no connection of me, my Lord, with regards to the incident case, Lordship. And one fact remains, Lordship, the main accused, all of them have been granted anticipatory bail in this connection, Lordship. And I was also cooperating, Lordship. It is not that I am not cooperating with the investigation. I was called on that particular day, Lordship. I went, I gave my statement, and from there, Lordship, I was taken to the custody, Lordship.
You have not applied for anticipatory bail?
No, Lordship. At that point of time, because, Lordship, I was not under the impression that, Lordship, I will be arrested. They had called me to the police station for giving my statement. I went there, Lordship, and from there, Lordship, they arrested me. Lordship,
what is the stage of the case?
Lordship,
what is the stage of the case?
Case, Lordship, it's
charge file.
No, Lordship, it is still at the stage of investigation, I'm told. At this stage, Lordship, I'm praying if the case diary may be called, Lordship, for Monday, Lordship. May fix it Monday, Lordship.
Monday will be little short on 16, your Lordship.
Lordship, 16, Lordship, because we are on the verge of vacation, Lordship. So if it can be on Monday or Tuesday, Lordship, because only 3 working days we have, Lordship, before the vacation, Lordship.
Monday will have to.
He says 16, you say Tuesday, so.
But Monday, Lordship, Monday, Lordship.
Let it be on 16, your Lordship. I'll take steps, yes.
Otherwise, Lordship, he doesn't have any connection with the instant case, Lordship.
Whatever, maybe you're taking a drop.
Produce the case diary.
Lordship.
On 16, your I'll produce your case diary by 16, your Lordship.
Heard Mr. S. Chandra, learned counsel for the petitioner. The petitioner was submitted that this is an application for grant of bail on behalf of the accused person, Shri John Larry Bhavok Carson, who was arrested on 6/11/2025 in connection with Ranja Police Station case, PS case number
311,
311-10-2025 under section 105 BNS. It is the submission of the learned counsel that the accused person is nowhere connected with the allegation made in the FIR filed on, lodged on.
FIR is lodged on, Lordship. That's that page 9, Lordship,
26/10/2025, wherein it was said that one male dead body was found lying at Demsinyong near Mausawa Shilo, later identified as
Charlie Print Group.
Charlie Pongru, and on being examined, the said body bore injury marks. The cause of death of the deceased, who was found on the at the said place, is said to be a result of an assault perpetrated against him. In course of investigation, the brother of the accused brother of the petitioner was arrested on being suspected of having a hand in the said assault, leading to the death of the said deceased Charlie Pongro. However, the Lord Counsel would maintain that the accused brother of the petitioner is innocent and not at all involved in the death of the said deceased. It is the further submission of the Lord Counsel that the other accused person implicated in the said case, that is Shri Ankush Marwanyang, and the bracket who was named in the FIR, and others have since been released, have since been granted anticipatory bail. At this stage, the Learned Counsel has submitted that the case diary may be called for, and on perusal of the same, the prayer of the petitioner may be allowed. Mr. H. Abraham, Learned Counsel, appearing for the state respondent, has also submitted that the case diary is required to be produced by this court, so as to confirm the involvement of the said accused brother of the petitioner. Accordingly, as prayed for, let the case diary be produced on the next date fixed. As prayed for, list this matter on 16.
Hello, Bletcher.
Hello.
Item number 3.
Yes.
My lord, if my lord pleases, because last occasion also my lord has cautioned me to take up the matter. My lord, today little bit of difficulty, my lord. I was again praying because I could not find any relevant case law in this context, my lord, regarding the powers of the deputy commissioner, whether it means the commissioner and secretary or the
that query was not posed only to you.
both of us.
Both the parties.
But it is my duty.
By now you must have got some authorities on that.
Praying if it can be taken at the end of the vote, because we have some judgments, Lordship, and Learned Senior is leading, so Lordship may have it at the end of the vote, Lordship. He'll be here to assist, Lordship.
My lord, let it be on the 16th, my lord. Waiting for the matter at the bottom of the list, my lord. No.
16.
Let it be after vacation, my lord.
My lord, let it be on 16th or 17th, my lord.
On 5th, Monday then.
Monday.
Monday.
But the parties list this matter on 15.
Item 4.
Take one Ashok 2.
Your Lordship, item 1 and 2 are connected. We are in petition is in item 2. Lordship, we've received the affidavit from the state. We require some more time to file our rejoinder.
The state has already filed their affidavit.
Yes, Your Lordship, we have received it. We need some more time to file the rejoinder.
Excuse me. Have you received copy of the
Lordship, on behalf of the respondent number 5, I pay to file the counter affidavit as well on the next date.
Miss Counsel for the petitioners has submitted that sometime may be allowed for the rejoinder affidavit to the counter affidavit filed by the state respondent 124 to be filed, since the same could not be filed today. Mr. Ibora, learned counsel for respondent 5, has also submitted that he may be allowed to file the counter affidavit on behalf of the respondent number 5. Pray aloud. As prayed for, pray aloud. This is matter of the petition.
Can I get the date, Lordship? Can I get the date, Lordship? Next date.
You suggest?
Lordship convenience. End of January.
This matter on 30th January.
Oblige.
Item number 3.
Took one class, see. Yes, have you filed your
Lordship? Yes, I have taken steps, Lordship, against respondent number 1 and 4, Lordship.
Have you filed your affidavit of service?
No, Lordship. I may be allowed to file, Lordship.
I'm preparing for 2 and 3, my lord, in this case.
Miss Direct Counsel for the appellant has submitted that the notice issued upon respondent 1 and 4 have been issued and the same have been received by such respondent. However, it is prayed that an affidavit of service may be allowed to be filed in this regard. Pray aloud. Mr. Akram, Direct Counsel has appeared on behalf of respondent 2 and 3.
No.
2 and 3. As prayed for, this is matter of the petition.
Oblige.
Dan issue tu pass over like that.
Cases, I think 1 in 30.